Good evening, this is John Milburn for Laws 11062. This is Contract B. We're into week 2. Thank you very much for joining me online. If you're watching this as a recorded session, please do try to join us Monday evening, 7 o'clock, Queensland time. Everything's Queensland time, including the first assessment that I've now released, which is due on Monday, 16 December, 11:45 p.m. Queensland time. I will accept late work, but to a degree. Your work needs to be presented to me by Saturday, 28 December. So a pretty generous window there. If you're late, you'll lose 5% per day for each day of late submission. It's not a difficult question. So don't be too concerned about it. Don't think that there's a lot of hidden material. There's not really. One of the things that I've noticed about answering legal questions is this, that when you're undertaking contract law, then naturally and probably sensibly, you want to answer the question based on contract. You don't really want to be talking about other aspects like torts or constitutional law or environmental law or whatever it might be. But with the work that I set, I'm always happy for you to identify that other areas may be relevant and to make a very brief note to that effect. So it's almost like an extra little bit of extra brownie points, a few extra marks. So please keep that in mind. But don't go overboard because it's not the main game, so to speak. So the main emphasis will be on, in this case, contract law and vitiating circumstances. The other thing that's very important to remember is that when you answer a question, you may, and very likely, subconsciously make assumptions. For example, you might assume that the contract is in Queensland. Now, that's a pretty reasonable assumption, but it doesn't hurt to say that. Those of you that studied Introduction to Law with me in Term 2 will know exactly what I mean, because we stress that in terms of the legal logic required to answer a legal problem well. So as you're answering the question, ask yourself, am I making some assumptions here? If I am, and they're critical, then perhaps you might like to call that, to identify it, to show that you're thinking broadly. I mean, a simple one is you assume that a contract is not statute barred. Sometimes we tell you the dates, sometimes we don't. So keep those sorts of things in mind. And of course, all of you, I'm sure, have your legal toolkit from Introduction to Law. Those of you that are studying contracts without having done Introduction to Law, my apologies. The toolkit is really just your document, your personalised document that gives you a head start on how to answer legal problems. So do keep those things in mind. The other thing is, when you're answering a problem such as the first assessment piece, it may be tempting to try to cover the field. So this is where you can go too far in identifying potential arguments. It may be that the question that I ask has elements of misrepresentation, unconscionability, duress, whatever it might be. You might think, well, that could be this. You may be tempted to list everything, but the problem is that when you're on a strict word limit, it sometimes reads as though it's an essay. It's an essay saying, if someone is involved in a contract dispute and there's something wrong with the way that the contract was formed, one of the parties was at a disadvantage, then it might be a case of A, B, C, D down to J. And then if you have 10 headings and you try to describe what it is, it looks like an essay. It sort of says, well, it might be one of 10 things and here's what they all mean. Sorry, I didn't have time to actually think about applying the law to the facts. So even though I'm suggesting that you might want to think laterally and broadly, sometimes you need to make a call. And you might say, I don't think this is duress, or I don't think this is unconscionability, or I don't think this is misrepresentation, and perhaps identify why it is that it's not, or leave it out altogether. That's the braver move to make. So if you think that this is absolutely a case that relates to the mistake of the identity of the other party, then you might want to talk about that. If you think it's a case about non est factum, you might want to talk about that and emphasise some of the cases that relate to those sorts of issues. So you're treading a fine line. Any questions then about what I've just said, or any questions about the first assessment piece? All good? You'll see that a lot of my questions follow a similar format, inviting you to prepare a memorandum to, it's always Margaret Smith, the partner in the law firm, that hypothetical law firm where you're working as a first-year lawyer. Part of the rationale behind asking you to answer a question like that is you're writing to me, and for the purposes of the assessment, I'm Margaret. What that means is I don't want you to tell me the 5 elements of a contract. I don't want you to go back too far. You can assume that I have a certain base knowledge, and I'm really testing you in relation to the more advanced areas. So, you know, unless it's critical to the answer, you probably don't need to tell me the difference between statute law and common law, or common law and equity. You know, you don't need to go right back and talk about the basis of, case law and precedent law generally. You understand what I'm getting at? So write to a certain level, and that's why I tried to structure the questions often in this manner. If you go over the word count, for me, it's not necessarily critical. If you go 10% more, then generally speaking, I'm really starting to look critically at your work. Now, that may be a good thing in that you may get more specific feedback. You might get some really insightful feedback, but you're probably going to get marked down, because once I start to look very critically at the work, it's easy, I think, pretty much in everyone's writing to indicate, well, you used 100 words there, you could have said that in 30, you know, and then the red pen comes out. So just be wary about going over the word count. Some unit coordinators require you to be very strict on the word count, and they will not, for example, read beyond 2,000 words, or they will not watch the video for your second assessment if it goes beyond 8 minutes or whatever it might be. So I'm just a little bit different to some. Everyone is slightly different. So know your lecturer, know what you can do, but work to the requirements of the unit coordinator for that term. All good? All right. We'll finish our discussion about mistake. We got to the stage of talking about mistake as to the identity of a party. And of course, that might be an important issue because you might specifically want a particular person because of their skill or reputation or whatever it might be. And we all know the basic distinction, don't we, between mistake of identity in 2 circumstances. 1, where it's face-to-face, and 2, where it's not face-to-face. So increasingly, of course, contracts now are not face-to-face. So if they're face-to-face, the presumption is that you do intend to make a contract with the person in front of you. If it's not face-to-face and the mistake as to identity is critical, then it is possible to ask a court to void that contract. Another type of mistake is to the nature of the document. I mentioned earlier non est factum. Can anyone tell me what that means? That little bit of Latin, non est factum? You can unmute the microphone or you can use the chat facility. What's it mean in English? Non est factum. Yes, Jessica.
It is not my deed. Yeah, it's already written there too.
I just couldn't quite hear you there. Not my deed. All right. Thank you. And I just couldn't quite hear you there, Jessica. I'm not sure if your colleague could hear you as well, but not my deed. So not my deed, Petlin and Cullen is the authoritative case on that point. And of course, the rule in Lestrange and Graucob is that if you sign a document, you can't use a defence, well, I didn't read it all. I wasn't aware of the full contents. Otherwise, we'd never have a contract formed over the internet, would we? It's really funny, this, because when I'm preparing for sessions such as this, I go back to what I learned in the 70s, and you just remember non est factum. You remember Lestrange and Graucob. You remember some of these terms. So the contract law hasn't changed a whole lot in some ways in all of that time. So understand when non est factum might be relevant, but the starting point is you've really got to be part of a relevant class of people. You can't read, you might be blind, might be illiterate in English, things of that nature. In other words, unless you're part of a relevant class, you can't get your foot in the door to plead non est factum. Why do I use the word plead? Can anyone? It's a very particular word in law. You can't plead it. What does that mean? Apply, yes. Apply to whom and in what context? When do we use the word plead? As a defence? Yes. A defence in court proceedings. So when we use the word plead, we're really making a reference to a thing called pleadings. Has anyone come across pleadings? It's really from civil litigation, civil lit, as we call it, as opposed to crim. Does it come down to a statement of fact or statement of law, says Gary? Yeah. So pleadings are the set of documents that we typically find or use as lawyers to make out our case. It's not evidence. Pleadings are not evidence. But when we talk about pleading something, it's really something that is contained typically in a statement of claim or a defence, for example, maybe a counterclaim, which is a formal document that sets out your case. Some questions during the course of university studies will require you to undertake some form of pleading, which means very formally saying, here are the elements of the case, here's how I'm pleading the case. So if you're arguing something like non est factum, you need to plead in the pleadings, the documents that are filed in court to make out your case. Things like, you know, the plaintiff is a member of a relevant class. Particulars, a person who's unable to read or is blind, things of that nature. Anyway, so you'll hear me talk about pleadings, and I'm sure you'll hear it often during the course of your studies. Now, unilateral mistakes, difference between common law and equity. I trust we know the basic difference between common law and equity. Confusingly, those decisions that are based on equitable principles form part of the common law. So there's some awkward terminology in all of this. But at common law, if a party makes a mistake, they can't rely upon that to void a contract. But in equity, where there's a unilateral mistake, it is possible to set aside or void the contract, or to rectify the contract, or perhaps refuse a remedy of specific performance that's being sought against you. Quick quiz. If you ask for a contract to be set aside, or you ask for a contract to be rectified, or you ask for an order for specific performance, what type of remedy is that party seeking of the court? What's a good word to describe the type of remedy? Damages, not what I'm looking for. Good guess, but no. Rectification, that's one of the three examples. Not exactly, a bit broader than that. So if you ask for an order setting it aside, if you ask for rectification, specific performance, declaration, they're all examples of equitable remedies, as opposed to damages, which is typically common law. But again, confusingly, it is possible to claim damages in equity, equitable damages. Don't worry, it just becomes part of the fabric soon enough. But at an early stage, if it's not in your toolkit, I would recommend that you add in some commentary, just a brief note of what are some of the remedies that are common law based, what are some of the remedies that are equitable based. Then you've got a ready reckoner, because some of the questions may say, it might be very specific. Applying equitable principles, what remedies would you expect Jack to potentially have in this case against Jill? All right, rescission. So equity looks at things a bit differently. We know that it means based on fairness, and sometimes equity will come to the aid of a party that has been the victim of sharp practice. So even though the party may have suffered as a result of a unilateral mistake in entering into a contract, signed the document, can't claim non est factum, the document's there, it's signed, but there was a bit of sharp practice on the other side, then it may be that equity will assist that party. The leading case, Taylor and Johnson, there has to be a serious mistake or an apprehension as to the fundamental term is number one. Number two, the other party has to be aware, or at least reasonably believe, that the other party is under this serious mistake. And number three, the other party deliberately sets out to ensure that the first party is not aware of the existence of the mistake or misapprehension. So that's potential arguments based on equity that you can apply when you have a unilateral mistake contract or argument. One of the things that you might have to get used to is this. It hurts, but you might have to get used to it. We've all been there. I've done this. You look at a question, you determine at a pretty quick stage that it's a unilateral mistake question. You then embark on the answer, and 1,200 words in, you get to the third element. In this case, that the other party deliberately sets out to ensure the first party does not become aware of the existence of their mistake or misapprehension. And when you look at that and you think about the facts again, you think, I can't make out a case. I couldn't plead a case here successfully that the other party deliberately set out to ensure that my client did not become aware of the existence of the mistake. So it's important before you start to write, particularly lots of words, that you think about all of the elements that might be relevant for a particular cause of action and work through that. It's a bit like if you play chess, you want to try and map out at least a couple of moves in advance, don't you, before you go into it. So same in writing in law. That's particularly the case if you're under pressure in an examination. So what do we do as part of our preparation for the examination, bearing that in mind? Anyone got any tips on how to avoid a situation of being 40 minutes into your written examination, you've written 2.5 pages, and you suddenly realise this is the wrong principle? How do you avoid that? Iraq, yes, says Harley. Yep. Any other ideas? I'll be more specific. How do you do something in week 2 that will help you to avoid this situation in exam week in week 13 or week 14? What should we be doing this week to help avoid that nasty situation? Matthew says, identify the legal issue early. Yes. What's a good way of doing that? I mean, because by the time you finish contract law, you're going to have cases and principles all over the place. Gary says, develop a note, a toolkit. Yes. Natalie, practice problem questions. Oh, I like that as well. Matthew says, break down the facts. Peter says, preparation, review exam notes. Matthew says identify what's relevant. So all of those are good answers, but you need something that works for you. I mean, it might be, for example, that from your mass of material, which are the notes that you've made from the textbook, the cases, other commentaries, the casebook, and the study guides, that you prepare dot points in something that works for you. Now, remember, of course, this is an open book exam that you're facing in the examination. So you can take in whatever you want. Some people might like to use cards, a card system. Others might like to use something that is like identifies with flowcharts, whatever it might be. But you need to start thinking about that now, is really the point. So I've asked you to consider a question where there's no specific answer, which is very typical of law studies. We ask you these questions where there's not necessarily a right answer, but that's good. Samara says, I make good content pages for all my notes and answers. Good. Okay, so contents page. So equity, of course, means that you may have an advantage in that you can set aside a contract. You'll need to understand the difference between rescission and voidable and void ab initio. And rectification is an equitable remedy. Rectification means fixing it up. If we rectify something, that means right the wrong in a way, doesn't it? So rectification is an equitable remedy where the contract can be amended effectively to reflect what it should have been rather than necessarily what it was. It's a pretty tough ask to get a rectification claim through, but it's possible. All right. X and Y make a mistake. They make exactly the same mistake. Quick vote on your buzzers. Is that a common mistake or is that a mutual mistake? Very good, Gary. Oh, you're onto the... Did you? Everyone's got it right and immediately. Were you all waiting for me to answer that, to ask that question tonight? Excellent. All right, so it's a common mistake. So it's the same mistake. It's a common mistake. A mutual mistake means they both made a mistake, but it's a different mistake. So great peace shipping and Sableris must be a common assumption, which is wrong. Neither party must have given an undertaking that the circumstances are true. Neither party is responsible for creating the error. As a result of the mistake, performance is impossible, and the mistake might be about the subject matter or the circumstances that are vital surrounding it. So when you're creating your checklist so that you can quickly scan a possible argument after you've read the facts of a case, you want to have those key words, don't you? So you can identify, number 4, performance of the contract is impossible. For example, that may or may not be relevant to the facts that you've read. So again, go back to having, as Samara would say, have a good contents page for all the notes, if that works for you. So common mistake talks about the existence of the subject matter, res extincta, or mistakes as to the title, res sua. I guess one of the leading cases, McRae against Commonwealth Disposal Commission, you would have all seen that case. After the war, the Commission allowed people to tender for salvage operations. A lot of ships down on the bottom of the ocean. McRae tendered successfully to purchase an oil tanker, but it wasn't there. It just didn't exist. So the argument was, of course, well, sorry, but we've both made the same mistake. Would you believe it? There was no oil tanker there at all, so all bets are off. But the High Court said, no, we can't have that situation because this is not a common mistake. The Commonwealth and McRae made a mistake, but McRae acted on in reliance upon the Commonwealth's statement. So if you have that quick checklist, you would say, yes, but element number 3, neither party is responsible for creating the error. The Commonwealth Disposals Commission created the error, so therefore this is not truly a case relating to common mistake. You don't want to realise that when you're half a page of writing into the thing, because then you just cross it out and say sorry and start again. So quickly identifying what are the potential arguments. Identify, usually it's 3 or 4 or 5. In contract law, so often you've got 3 or 4 or 5 dot points. Have a word or 2 or a phrase that makes sense to you to immediately work on that and then apply it in quick time. Leaf and International Galleries, again, a case I remember from the 70s. Gallery purchased a painting, believed it was from a famous artist, but it was a forgery. The court said this is not a common mistake. All right, so in relation to common mistake, by the logic of some of the cases, you might think that the only times that there could be a common mistake is where there's a common thought, which is said or which is unsaid or undocumented, or both parties said and documented the same mistake simultaneously without one relying on the other. And that's going to be pretty rare, isn't it? Because usually the mistake, the common mistake, will come about as a result of one party causing this situation rather than them both stumbling across the same mistake at the same time. Anyway, just some food for thought. The reason I'm saying that is I don't really think that common mistake is actually used that often in practical terms. And indeed, it's fair to say that a lot of what we're discussing now, which is based on the common law, was revolutionised by the introduction of the consumer protection legislation. What's the most important piece of consumer protection legislation in Australia, do you think? Gary says the ACL. Jessica's more specific and says Section 18 of the ACL. Peter says ACL. All right. Is the ACL Commonwealth or state? Commonwealth? See, it's a trick question. Well done, Jessica. It's both. How can it be both? How can it be both? Natural person? Yes. Yes, Jessica?
The state and territories mirrored the Commonwealth legislation.
Very good. And what's the name of the legislation in Queensland that caused the ACL to have applicability in Queensland as a state law? Fair Trading Act. Very good, Gary. That's it. So we call it the ACL Queensland, I think, is the official term. But I digress. So most of these cases now really are decided under the ACL, but we still need to know these common law principles, the equitable principles in particular. So remedies for common mistake: rescission, which is an equitable remedy; rectification, which is an equitable remedy. And rectification means changing the contract to reflect the actual intention. So if you're going to argue rectification, 2 elements, you'll need to have those written down, dot point form, ready to go. And it's also useful to have a leading case or 2 as well. And when you develop further, what you might do is identify sections of the ACL that actually look a bit like some of the common law remedies. So if you can cross-reference those as well, that will make it much quicker for you in answering a question so that you can identify causes of action that you might plead based on common law or equitable principles. And in addition to that, you might plead as an alternative remedies that are available under the statutory provisions, under the ACL particularly. In other words, it's quite common in law to have 2 bites at the cherry or 3 or 4 bites at the cherry. So in your pleadings, you might say that in relation to these matters, the plaintiff is entitled to a remedy at common law, being this, or under the statute, being that. So it's not a mistake to identify 2 potential causes of action in relation to the one matter. When you're looking at these matters, remember, of course, that we need to generally adopt the objective test. We talked about that last week. So we'll know what the objective test is as opposed to the subjective test. All right, let's digress for a moment now. We'll just talk generally, just away from contract for a sec. Can I ask this, has anyone come across the Student Success Centre at Central Queensland University? Anyone access that service? All right, it's worth looking at. So the Student Success Centre provides personalised service for a whole range of different things, and you should be able to find that through MyCQU, but student support at cqu.edu.au might be the way to go. That's if you're looking for some extra help or some additional guidance. As we said, studying law is stressful, so sometimes you need some help. All right, so in terms of your progress in Contract B, by now you should be reading your material at least 1 or 2 weeks in advance. You should have mapped out your plan for preparing the first assessment. Before you start an assessment, I think it's always a good idea to have your template set out. I get quite cranky if you don't undertake some basic tasks for me. For example, I don't want to say this document was not paginated again. Most unit coordinators won't be bothered about that, but I am. It comes from being in practice for so long that you don't present something to a court, for example, or even a client if it's not paginated. So it's got to be identifiable is really what it comes down to. So get into the habit of that. If you know that you've got to answer a question, why not have your own template set up the way that you like to set it out, so that you've got it ready to populate, as we say, with your own content. So have some good templates ready to go, rather than just necessarily a blank page. It's a useful start, because if you've got some template to start, it's easy to get moving rather than that completely blank screen. So that's what I invite you to do. Now, with the assessment work, as I said, make sure that it's on time. If you haven't looked at my sample document, please do so. It's in assessments, and it just gives you an idea of what you can look at, how you can set out a document with a few basic tips. The other thing is that Dr. AJ George has prepared some very good material in this unit. And before that, Anthony Marinac prepared some excellent material. So do have a look at that. AJ prepared a lot of great material on Iraq. So please study that carefully and try to apply that. The other thing that I'm really keen on is ensuring that you're by now becoming more familiar with the Australian Guide to Legal Citations. So what that means, you must know how to footnote reference, and you must be able to please ensure that if you type legislation, it's italicised. If you type the names of litigants in a case, Donoghue and Stevenson, it's italicised as well. The other thing, just as this is a quick note as to the second assessment, when you're on your feet and presenting an argument, if you refer to a case in Australia, we don't say versus, we don't say v. Typically we say and. So it's Donahue and Stevenson is what we say, not Donahue v. Stevenson or versus Stevenson. V's not too bad, but versus is definitely, that's a rookie mistake. You'll look like you just don't know what you're doing if you say that. So just get to know some of the little subtleties in terms of presentation. If you want some really good videos on how to present court arguments, then I'll see if I can dig some out and put them on Moodle. They're really entertaining anyway. Anyway, I'm digressing. So we were talking about AGLC, and please ensure that you understand that principle. All right. Okay, I'll do that. I'll put on some funny videos. Well, one in particular that I've got in mind. Top 10 tips for cross-examination. So I mentioned earlier the distinction between common law and equity. You'll need to know that for the purpose of any assessment to do with contract law. But I said confusingly, when the cases in equity are decided, they become part of the common law. So the authority for that is Lang against the Australian Broadcasting Commission, or Corporation rather, 1997, 189 CLR 520, where in Australia, common law includes both equity and common law, which is collectively called the common law of Australia. We could have done better, but that's the way it is. If there's a distinction to be made between equity and common law, then equity prevails is the general principle. And when you're applying equitable principles, if you're asking for an equitable remedy, then just remember that there are some basic rules. One of them is one who comes into equity must come with clean hands. So if you're raising an equitable argument, then you must have clean hands. What do we mean by that? What do we mean by you must have clean hands? Hope we're not talking literally. Any thoughts? I can see your mouth moving, Gary, but you'll need to unmute.
Sorry, you there?
Yes.
Yeah, so the person who's making the claim must come and not have done any wrong in that circumstance?
Exactly, yes. Or it might be wrong that's explainable. And Matthew got the same thing as well. So just be prepared for that argument that if you're asking for an equitable remedy at all, you need to examine your own conduct. Now, part of the main emphasis of the first part of this unit relates to misrepresentation, misleading and deceptive conduct. So here's where we really do have the amalgam of the common law and equity on the one hand and statutes on the other. So section 18, Jessica will tell us, is very important because that's a key section in the ACL that deals with misleading and deceptive conduct. But it's an equitable principle, it's part of our common law as well. So there are some implications for parties that engage in misrepresentation or misleading and deceptive conduct, but it's subtle in many ways. And we need to then categorise the type of conduct. Misleading or deceptive conduct, according to the study notes, means being able to establish to the satisfaction of a court to the standard, to the requisite standard on an objective test that the conduct had the tendency to lead a person into error. If the conduct had the tendency to lead the person into error, then on its face, it's misleading or deceptive conduct. Misrepresentation is a bit different, and confusingly, there's not one or two, there's three different types of misrepresentation: innocent, fraudulent, and negligent. When we start talking about fraudulent, we're really crossing into criminal law, aren't we? When we're talking about negligent, we're really crossing into torts law. So if you've studied those things, you might be at an advantage in that you'll have some of the general principles in mind. But if not, you might need to consider just doing a little bit of broader research to get an idea of what we mean by that. And then, of course, as we come to expect, there's a distinction between establishing certain things like misrepresentation at common law as opposed to establishing misrepresentation in the equitable jurisdiction. So there are 4 elements for common law misrepresentation: a full statement of past or present fact. So it can't be something that relates to the future. It's got to be a misrepresentation of that which is happening or which has happened. Of course, it needs to be addressed to the person who is claiming to have been misrepresented. And it must happen at or before the time when the contract is made. It can't be a misrepresentation after the contract was signed or made. So you need to be very clear, this is contract A stuff. When was the contract made? Was the misrepresentation before that event, or was it at the time? If it's afterwards, you can't. And what was the intention? Was it intended, and did it in fact induce the representee to make the contract? So these are some of the basic elements. And again, have your checklist set out. You're scanning through this long, convoluted set of facts where, I don't know, what would you say, just as an idea, when a unit coordinator, lecturer prepares a set of facts, how much of it, how many of the facts are actually material and how many are, what do we call them, red herrings? Just guff that we put in? Probably, I don't know, 20%, 30% of the facts are actually important. The rest are just things that we make up as we go. That's a little trade secret, just to throw you off the hint, off the scent a bit. So you've got to identify the material facts, of course, and then you've got to 10%, that was pretty close to what I thought. So 10% is probably about right. So what you've got to do is identify the material facts that might be relevant to some type of cause of action. And then once you've done that, very quickly cross-reference them to what you've prepared as your checklist, your just little quick guide, your little ready reckoner, whatever you might want to call it, to say, does it fit within that category? Before you start to write 3 pages of handwritten notes and realise you're on the wrong track. So categories of misrepresentation: innocent, fraudulent, negligent. Go back to Derry and Peake is the old English case that identified those. But of course, as we mentioned, Section 18 of the Australian Consumer Law is really the important thing now. In fact, it's by far the most common way of pleading these sorts of cases. You might plead common law, but really you're likely to rely upon the ACL. So when you're preparing your work, I think a good starting point are the flowcharts. These, I think, were developed by Dr. Marinac. They're really good. And you've got the flowcharts for weeks 1 and 2. Has everyone looked at that? And can anyone tell me if they actually find them useful? Had they been a good way of looking through? Yep, I did. I found them really useful. So they are very good. They're great. So please use that, but don't rely on it totally. I want you to supplement it with your own notes, something that makes sense to you. Use them as a starting point, but go beyond that, I think, is the important thing. All right, so innocent misrepresentation, fraudulent misrepresentation, and negligent misrepresentation. Again, there are certain conditions, aren't there? So for fraudulent misrepresentation, which I said is kind of bordering on crime, it's not really. It's really a tort. So, as is negligent misrepresentation. But what are the conditions, for example, for fraudulent misrepresentation? Number 1, a party knowingly makes an untrue statement. So the party has to make a statement. The party has to make a statement that is untrue, and they have to know it's untrue. That's the first element. Number two, when the party knowingly makes a partial statement, which is a half truth, then that may also be, that's one of the conditions as well. Number three, when the party makes a statement, they don't care whether it's true or not. And the fourth is when a party makes a statement with no belief in its truth. So they're the four types of conditions that it might be in relation to fraudulent misrepresentation. Negligent misrepresentation. Well, again, we go back to torts law and we talk about duties. Has anyone studied torts yet with Anna? I'm getting a few. Anna's great. You'll really enjoy studying that when you get to do that unit. It's a lot of work in it though. But you'll come across negligence. So negligence, three elements. Number one, there must be a duty of some sort. If you don't owe someone a duty, then there can't be negligence. Number two, the defendant has to have failed in that duty. And number three, there must have been some harm that arose from the failure. In other words, loss or damage that was caused by the breach. So what are the key words if you're looking at negligent misrepresentation? Can anyone give me 4 words that are the key words? Bang, 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 and bang. All right, so we're getting votes for duty, breach, causation, harm. Gareth says duty, breach, harm caused. Loss, Harley says remoteness. Duty, failure, loss, causation, says Samara. Some good answers here coming in. Well, guess what? There's no actual right answer. You have to come up with your own, something that makes sense to you. The 4 that I have are duty, failure, loss, causation. But that just works for me. I thought Gareth and Samara's were really good. I'll read them again. Gareth says duty, breach, harm, and cause. Samara says duty, failure, loss, and causation. Well, that's exactly the same as mine. So that's, but different ones apply. So you need to be able to identify these things quickly. This all goes back to a really important English case called Hedley, Byrne and Heller. It's actually longer than that, but we always say Hedley, Byrne and Heller. Hedley, Byrne and Co. Limited against Heller and Partners Limited, but Hedley, Byrne and Heller. So what happened is Hedley, Byrne, advertising agents, had a new client. Before extending credit to this new client, sought an assurance from the bank, Heller, about the credit worthiness of this company. And Heller, the bank, said they're fine. But the company went into liquidation pretty quickly. So Hedley Byrne sued Heller, the bank, in tort, successfully arguing, essentially for the first time, that their economic loss arose directly as a result of the negligent misrepresentation made by Heller. What that means is we're all now very, very careful about what we say, which is kind of a little bit sad, but it's the truth. So Hedley, Byrne and Heller is a landmark case that deals with these issues. Now, let's have a look at Gareth's 4 words. Duty. What was the duty in Hedley, Byrne and Heller? Who owed a duty to whom? So who was the bank in that case? Heller? So who was the representee? Hedley, Byrne. So the bank had a duty to Hedley, but of course, Hedley-Burn was not a customer of the bank, were they? Well, they might have been, but that wasn't the basis upon which this case was argued or successful. The court found that there was a duty, and of course there has to be a duty, otherwise it wouldn't be negligent misstatement. The court said there is a duty here in circumstances where there was, and here's a really key phrase for you, you want to write this one down, sufficiently proximate as to create a duty of care. So there was a relationship between Hedley-Burn and Heller, and how close was that relationship? Well, close enough to create a duty because the parties were sufficiently proximate to each other, whatever that might be. And Samara's right. So the bank failed to provide accurate information and Hedley-Burn lost money as a result of that. So the first thing is there was a duty. Heller had a duty to Hedley-Burn to ensure the information it provided was accurate. Now, the next one we'll go with, we'll switch now to Samara, who said the second element is failure. So what was the failure? What was the failure? Failure to do what? Where did they fail? Tanya, the information was not accurate. That's right. So they failed in their duty. They had a duty and they failed. Now we'll go back to the third one. If we go to Gareth, he says harm. So where's the harm? And the harm to whom? The harm has to be to Hedley-Burn, hasn't it? Howley says the loss of money. Absolutely. And Tanya agrees, the loss of money. That was the harm. And the final one is causation. So pretty clearly, the loss of money was directly caused as a result of the failure to fulfill a duty that was owed to the sufficiently proximate other party in that case. Now, in a way, it might be easy to see this if you're reading Hedley-Burn and Heller and you're thinking at the moment about negligent misstatement. But in 3 weeks, we're not going to be talking about Hedley-Burn or negligent misstatement. We'll be talking about something completely different. If I gave you a case, a scenario, and said, what do you think this is all about? Because only, well, if we go by reckoning of, now who was this who said 10%? I'll find you. Peter, yes. If we go by Peter's reckoning, only 10% of what I tell you in the facts of a case is actually relevant to the case. So you may not spot it. But if you do find that relevant 10%, or whatever it might be, that is actually material, then somehow you've got to remember, okay, you've got to associate that with negligent misstatement. Might be some other things as well. That's where you've got to ingrain these things. So when you're undertaking your reading, read very actively, please, and write as if you need to unravel a problem somewhere down the track that relates to this situation. So what are the key words? What are the clues is what you're creating for yourself when you're reading cases. You need to identify the key thoughts that are relevant to this. All right, so on misrepresentation, what are some of the key thoughts? Well, from what we've discussed so far, misrepresentation applies to past and present facts. There are 3 categories of misrepresentation: innocent, fraudulent, and negligent. If a party receives the representation, does not believe it, then it can't be a misrepresentation, can it? So there's got to be a belief there. Now, these aren't necessarily fitting neatly into Hedley-Burn and Heller, are they? Because now I'm adding extra things, even though we talked about negligent misrepresentation, now I'm adding some extra things. the party making the representation may believe it to be true, but the statement may in fact be a misrepresentation. And even if the parties believe the misrepresentation, it might still be a misrepresentation, is another key fact. Any questions? Are you still hanging in there? No questions, or no, I'm not hanging in there? We'll go with no questions for that response. All right, so no questions. Very good. Remedies for misrepresentation. What are the main remedies for misrepresentation? Rescission and damages. Yep. Damages not available. Can you get damages for innocent misrepresentation? I almost gave the answer there. No. Yeah, very good. Not in Australia, at least. Consider exclusion clauses and misrepresentation. So when a party is usually bound by all the contents, even if they haven't read it. We know that. But a clause is not legally enforceable if a party that drafted the clause misrepresents the effect of the clause to the other party. So an exclusion clause that's not legally incorporated into a contract might still be the subject of a misrepresentation if one of the parties gave a wrong impression as to what that clause meant. And that makes sense, doesn't it? There's a key distinction here, and I know we're getting very close to the end, but I'll stop the recording, and thank you for your patience. But I need you to understand a distinction in the context of remedies between affirmation and rescission. They're kind of the opposites. If one affirms, then one does not rescind. If one rescinds, one does not affirm. So if a party discovers a misrepresentation, the preliminary advice initially is, what are you going to do about it? You've got to make an election. The party that is affected has to make an election. Do we affirm the contract or do we rescind the contract? Now, has anyone bought real estate, or maybe people act in a law firm and do conveyancing? If you read the special conditions, or the standard conditions rather, of an REIQ contract, you'll see this reference to this specifically. And it says, in certain circumstances, in relation to certain breaches, the affected party may elect to either affirm the contract or elect to rescind the contract. But you've got to make it clear. So if you affirm the contract, it means I'm calling you, you've done the wrong thing, I'm still going ahead with it, but essentially I'm reserving my rights to claim damages. Or alternatively, I'm rescinding the contract, I want you to voluntarily say this deal's off, or otherwise I'll go to court and ask for a declaration, I'll ask for a rescission order. Do you understand what I'm getting at? It's difficult to tread the line between the two. And the case of Sargent against ASL Developments from 1974 in the High Court is authority for the proposition that once you make your election, it cannot be retracted. Now, ideally, when people make their election to affirm or rescind, they do so very clearly. But sometimes people don't, and we need to infer from what they said or what they did whether they had elected to affirm or rescind. Objective test or subjective test? I think I've got you on this one. Don't worry, it's the last thing we'll do. I'm getting a few different answers on this one. I think it's objective. A rule of thumb, if you're in doubt, I would think probably 9 out of 10, the answer will be objective. So if you're really in doubt, just go objective. It's probably going to be right. The other thing that you might want to consider is some unreasonable delay can be used as a defence against you. So if you may affirm or you may rescind, but if you rescind, let's say 3 months down the track or whatever it may be, you may have unreasonably delayed, and in that instance, the party might successfully argue that whilst you may have received a rescission order had you rescinded early on, because of your delay or latches, as we say, you've lost that. All right. So that's rescission and affirmation, affirming the contract or rescinding the contract. Please look out for that. As you're reading a case or a commentary, look for the remedies. See what the parties are actually asking the court to do. Look at what the court actually did and use that as part of your arguments in cases that you're writing about or you're arguing in this unit. You've been very patient. Thank you. Any questions before we wrap up for this evening? All good? All right. All good. Okay. We'll see you next week. All the best. Bye then.